Hi, I'm Debbie Moraes, and this is Legal Matters, the program that's designed to address the critical issues facing businesses and consumers today. It's legal information, practical solutions, and straight talk about a wide variety of topics. And as you know, we've been discussing everything from family law to financial matters and more. Most recently, we had been discussing probate, and at the end of the session, as we say at all sessions, if you have questions, please feel free to email them at legalmatters@fullchannel.net. And while we decided that we would continue our discussion about probate because it encompasses many different topics, we wanted to first begin with a question that's going to be posed to David Bazar from Audette, Bazar, Cordeiro Grasso law firm in East Providence. Again, welcome. The question about probate was, what are the assets that are not likely to be tapped or problematic in probate?
All right, as I understand the question, and it could be taken in a number of different ways, but if the question is what assets don't go into probate, for the most part, any asset that's in a joint name will pass by that type of mechanism. The house that's in a joint name doesn't have to go into probate. Life insurance proceeds where there's a named beneficiary, those proceeds don't have to go into probate. A vehicle, if that's the only asset, there's a mechanism for passing the vehicle outside of probate. So, as you recall, we talked last time, probate is a way of changing the name on an asset. So, if the name doesn't have to be changed, then the asset doesn't have to go into probate.
So that would also mean if someone had some retirement benefits, a 401k or an IRA or whatever that vehicle is, and it named that beneficiary, that would not be something that would be subject to probate.
Correct, because by its very nature, the 401k has a beneficiary named. If the beneficiary is still alive, then that person takes it by the mechanism of the 401k, as opposed to having the name changed in probate court. And when I say change the name, it's not changing the name of the asset, it's changing the name of the owner of the asset.
And bank accounts qualify as well, I assume.
Exactly. Bank accounts create some interesting issues sometimes, and as we talked last time, there's been some case law in Rhode Island on when a bank account goes to someone else on the account, or when it was what they call for convenience only, which was a daughter may be helping a parent, or a son may be helping a parent with managing their assets. And they've told the bank, we don't want this account to go to that person, they're just helping us. That's for convenience only. So then that asset would have to pass through some other mechanism like probate. However, if it's with right of survivorship and you tell the bank that this is a joint tenant on the account, then the account goes automatically without the need for probating the asset.
It certainly sounds that, from what we discussed last time, that probate can be quite cumbersome and involved. I think it probably is a good idea, considering we'd like a little bit to explore living trusts today and how people can avoid some of the problems associated with probate. Could you go through that process again for us, David, so that we know how to step through it,
right,
if you would?
Somebody dies. The first thing that happens is, in terms of probating the estate, if there's a lawyer involved, the parties go to the lawyer, and you have to determine whether or not there's a will or no will. If there's a will, you send the will in to be admitted to probate. And that step is a fairly easy process of notifying all the heirs at law, so if anyone wants to challenge the will, they can. Advertising so people know that the will is being admitted to probate, and creditors are notified of that. And then you have a hearing in front of a judge, and the judge goes through to make sure that the will is properly executed and valid, and if they find that that's the case, and the will is then admitted to probate. The next step after that is there's a 6-month period of time where the estate has to remain open so creditors can make claims. And during that period of time, the person who's appointed executor, which would be the person named in the will, goes about gathering up all the assets and marshaling them into an estate account so that they're available to pay debts and so forth, and also available at the end to distribute to the beneficiaries as named in the will. Now, during that period of time, claims can come in, and there's a priority. Let's suppose we have a relatively small estate and there's not going to be enough money perhaps to pay all the claims. the probate statute lays out an order of preference for what gets paid. There must have been a strong funeral parlor lobby at one time, because that's the number one priority and preference. Funeral bill gets paid. But there are other preferences. And a widow or children can request an allowance be made out of the estate so that they have some money to support themselves. So if there's not a lot of assets, it's not a bad idea to get it into probate so that they can make that request for an allowance. But then going down the line, taxes and debts where there are mortgages and so forth, those are actually a little bit treated differently, but unsecured debt goes through a little bit of list of priorities and then get paid out.
So David, if it's the spouse who ends up being the executor of the will, then that becomes the personal representative. How would she or he happen to know this step-by-step process unless they had a probate lawyer with them? And the probate lawyer is usually the one who works for the deceased at that will, correct?
The attorney for the executor or executrix is really representing the estate and making sure that the executor, and the difference between an executor and executrix is male, female. So the executor, the male executrix, the female needs usually to have an attorney give some advice as to what they need to do. But in most estates, they then go out and do the work. And by the way, they can be paid for that by approval of their fees through a probate, by the probate judge.
That's if it's not an estate, just a will?
Either way.
Either way.
If it's an estate without a will, someone who, they call it dying intestate, that person who's appointed would be called an administrator or administratrix of the estate. There are some differences, and the importance of having a will, one of the very important things to do is in your will to say you want your person who's serving to be able to serve without surety. And what that means is when someone comes before the court to be appointed by the judge as the estate representative or personal representative, as you said, the judge has to set a bond. And the bond is to secure their performance, to make sure they don't take off with the assets or do some other type of malfeasance. So the bond is set, and if it's with surety, then you have to get an insurance company and pay a premium to ensure the performance of the estate representative. And that costs money. So if you know who you're appointing and you do a will and you say, this is the person I want, that you can tell or direct the judge that you would like that person to be appointed without surety.
It seems that if someone were likely to say, gee, it's much less expensive if you don't have a probate lawyer, which we'd understand, sounds as if there are enough details to take care of that you would almost need to have them between the documents you need, the copies you need, this surety bond that you're referring to. It sounds like it could become quite costly. Could you give us some idea about what that range of costs might be, never mind for a probate lawyer?
Well, the cost of administrating an estate without the attorney?
Yes.
Well, there's a fee for filing, and the fee is basically 1% of whatever the size of the personal estate is, not including real estate, obviously. So if you've got a large estate, that number can get up there pretty high. There's a max, I forget whether it's $3,500 or $4,500 or something of that nature. So the filing fee itself on a large estate can be big. There are costs for advertising if that's necessary. If there's no will, there's a cost for the surety bond, which can be expensive depending on how big the estate is. So those costs can all add up.
And to have a probate lawyer again, as we
Well,
talked about briefly
yeah.
last time, but what would that cost?
It depends.
For a typically small estate, say it's under $100,000.
Okay. And now it's going to depend on the complexity of the estate, regardless somewhat of size too, because some assets are pretty easy to deal with. And you could have a large estate, a bank accounts, for example, without a lot of creditors, and that could be a fairly simple estate to deal with. The most difficult thing to deal with, as I've found, are people who hold their own stock certificates, not in an account with a stockbroker, and they actually have their stock certificates in their name. That is a nightmare to try to change to the heirs or the estate name.